No is the short answer. The phrase, not so much now, but previously business to business used to arise quite a little bit, but nowhere in the Act does it talk about business to business or business to consumer. The Act talks about consent to send a commercial electronic message. It talks about business in being consent as a recipient, but that being that the message is relevant to the business or all functions and duties of the recipient in a business or official capacity, but there's no mention of business to business or business to consumer. We have a matter with legal at the moment, legal services, where it's a very similar scenario. We look very closely at the definition of New Zealand link in our legislation, which is quite wide. And when we identify a nexus to that, and in the case I'm talking about, it's somebody that's basically told us that's exactly what they're going to do, but they're sending unsolicited commercial electronic messages to New Zealand recipients. And we will investigate and push that as far as we can to a compliance outcome. It's a very challenging environment, but we see things where people try to duck under the radar with those sort of activities, and that's when we pull out the Ways and Means Act sometimes. But the New Zealand definition, New Zealand link, is quite wide, and we can look very carefully at that, absolutely. Just because you're offshore doesn't mean you'll escape the legislation, essentially. It's more about what you do behind the conversation or after the conversation or at the point of conversation. You know, if you have a communication or a conversation with somebody and you get their consent, that should be something that if you're running your business in a way that you needed to capture that, you'd have a process that could be captured, that you could demonstrate and show that. So we wouldn't expect in time to go back to somebody's memory of a conversation, but what we would expect to see is that there was some sort of process or system or tool or policy in place that verbal consent was captured at the point of the conversation and can be referred to. And that would be reasonable, because sometimes we do get shown those sort of things when we ask the questions. You'll be amazed at the sort of information that we are presented with when we do ask for evidence of consent. You know, some people get written consent on a form, they'll scan it in and PDF it, and they'll keep an electronic copy. And I'll say, now hold on, here's the copy of the record, here's the lady we're talking about, here's the time and the date on the form, and here's her signature. Well, they're not going to have that unless it was a positive interaction. So yeah, you'd be surprised at the information that we get, but it's not impossible. But you'd have to have something in place behind that to demonstrate that. Look, we're very reasonable, we're very pragmatic, and we don't try and take a sledgehammer to crack a nut. But Section 9(3) of the Act says onus of proof is on the sender, not on the complainants. So you have that onus of proof. It's a difficult one. If you haven't been managing your list or your data in a way that you can confidently later demonstrate consent, you really have to ask yourself some strong questions about, should I market or should I promote to these email addresses? We'd look at reasonableness in relation to the process and system that was in place. When you start having those conversations and digging down to that level of detail, in our experience, it's very unlikely and improbable that a business will go to that level of detail in their explanation if in fact that was not something they didn't do. And we take those sort of explanations into account. We try to be as pragmatic as possible. It's not sometimes as simple as, well, we've done it this way, because we have to look at the nature of the whole operation, if you like. We have to look at, you know, when consent was captured, when the messages were sent out. If it's true express consent and that conversation has taken place and the business are operating in such a way as they have a business process to capture that consent onto a database, that's not unreasonable. And if we see one complaint and they say, well, we've sent out 5,000 messages to consent we've captured in this nature, then that obviously gives us a strong indication as well that maybe things are okay. Absolutely, absolutely. And positive opt-in is always best. But how would the business have the recipient's email address in the first place is the question. There would have to be a positive interaction and communication between the customer and the business for that data to be acquired in the first place. I can see that in the nature of the conversation, it hasn't been explicitly stated that we will be sending you electronic messages. If you're using inferred consent in that environment, again, by virtue of the nature of somebody going into a store and purchasing a single product in and of itself wouldn't be inferred consent. That person might just call into the store once and never go there again. So there has to be a little bit more to the loyalty program. And generally, look, I'm in a few loyalty programs, but you know, I know exactly what I'm signing up for, and it's my positive interaction because I want to receive those commercial electronic messages. So I know it pops into my inbox. So it's about that, the quality of the communication at point of contact, which is really clear, same as T's and C's. Again, you're displaying terms and conditions, but you have to make that connection with the process of providing consent. You have to try and join the two up. It would be the same as one of the case examples I gave, whereby the company was saying, well, we had terms and conditions on our website, but there was no direct nexus between the opt-in and the terms and conditions. They were so far removed that it wasn't reasonable. You can't send a commercial electronic message seeking to gain consent. Again, potentially it may be. It would depend, again, that holistic view and approach, what the nature of the event was. Is it an event where lots of the same type of people go to every year because that's the event that they do, for instance? Again, if there's no interaction at the point that the email address has been obtained, relevant to how that email address may be used for future marketing and promoting too, then you might be on a little bit of shaky ground there. But again, err on the side of caution would be the response from the department in relation to consent in that example. Okay, so if 11.2 is alive and it exists, and there's a contract arrangement or understanding between the sender and the recipient, you don't have to include and subscribe, period. Best practice is that you do give them an opportunity. Yeah, that is correct, yes. If they've signed up as a whole to receive the commercial electronic messages, but this commercial electronic messages is about the event component of it, well, they can unsub from the event component, because we would look at the form and content of the message and understand the business behind the message as well. So we know it would be subdivided all categories, and it wouldn't be unreasonable for a recipient to opt out of the event category, as long as that's what the form and content of the message said, and it was something that wasn't sort of lost in translation, if you like, in relation to the correspondence and the transaction, if you like. Conspicuously published is conspicuously published. It doesn't have to be on the internet. It can be in a publication. It could be in a manual. It could be in a phone book. It could be in a lot of things. You used the example business card. Again, we haven't had any interpretation of whether that would be conspicuously published by way of case law, but look, it's on a business card that's been handed out, so it's reasonable to accept that it is conspicuously published and it's handed out, and it's, I guess, in and of itself a publication. How you would use that, though, would be maybe restrained a little bit in relation to the nature of the exchange of the business card, because back in the day, this type of discussion around business cards generated a lot of questions for us. People would go along to events and throw the business card in a bowl and be receiving commercial electronic messages maybe 4 or 5 or 6 weeks later, and there was a breakdown in communication relevant to the collection and use of those business cards. There is some information on our website about that, but from a literal interpretation, the department would be comfortable in saying that an email address on a business card is conspicuously published. The department's always taken a position from day one that it's a positive opt-in interaction as opposed to a default checked even if they can uncheck it. We've always said positive interaction. Extending that a little bit now, because you're having a prize competition, as you'll probably be aware, it then gives you a, well, for want of a better word, a second bite at the cherry, because you would obviously have an obligation to inform all of the people that enter the prize competition of the result of that competition, to say, well, you've won, or well, thank you for entering, on this occasion you haven't won. And therein, because that would be not a commercial electronic message as defined by section 6B, excluded, and because there's a reasonable expectation that you communicate the results of the competition to the people that entered, that may give you a window of opportunity to capture consent at that point as well. My understanding of the Gambling Act in relation to prize competitions is that there is an expectation that the results of the competition will be communicated to the people that have participated. So within that communication, there's a window of opportunity, and it's reasonable because you are informing them of the result, that you could get consent at that point. Yeah, if you want to do that, that's fine, because it's terms and conditions, it's upfront. You are communicating an expectation to the person who makes an informed decision that they know by entering the competition they're going to receive commercial electronic messages. That's perfectly reasonable. We haven't seen a lot of complaints in relation to that activity at the department. And again, we'd look at it from a holistic perspective about numbers and about the mechanisms under which it's done and the reasonableness of it as well. And then you start getting into the realms of, is this incentivized? What's in it for the sender? Do they earn points or rewards or bonuses? How much is it encouraging the person to send under the guise of consent a lot of information which potentially is unsolicited? And then we start digging down into areas that maybe we're not so comfortable with. I think it's the best answer I can give you. Discretion is a very strong word for us. We have a compliance service delivery model, and everybody that we deal with puts themselves in a different box in relation to their reaction and interaction with us. And we don't have to go for a formal warning in the first instance. Sometimes we go straight for a search warrant because the circumstances are so serious and we know that the person is not going to comply. But there's a lot of thinking that goes on behind that as well. 98% of the organisations and individuals we've dealt with, through a written formal warning, go off our radar and we don't see them again. Ones that have drifted back on, well, we're not going to get another formal warning, I'm sorry. It's going to be a civil infringement notice at the conclusion of an investigation if our decision making is sound and it backs that decision up. But we have, as a regulator, a discretion to go in at any point. But that is triggered by a lot of indicators. It's not just an ad hoc decision that's made by an individual, because we have to think about risk as well and our reputation. And if we're not consistent, we'll get pinged and examined quite closely, potentially in a court environment, and that's where we have issues. So that's why we're very careful about our decision making, but we can go in at any point. A civil infringement notice carries a fine with it. The penalties under the Act are, for an individual, a maximum of $200,000, for an organisation a maximum of $500,000, for a civil infringement notice per event, so that's per one breach, per one email. For an individual, it's $200 a maximum. For an organisation, it's $500 a maximum per event. So we don't publicise the amounts that we fine. That's a decision that we've made. And going forward, we just apply our thinking and our logic around what we see, how we interpret it. A lot of emphasis is based on the interaction that we have with the organisation and their willingness otherwise to demonstrate compliance. As long as you've captured opt-in, because that's express consent. We had a 1900 and frozen to death in 2007, actually, not long after the Act came out, a big campaign to people that had 2 years prior to that opted into a competition to receive some gold earrings as a prize. And all of a sudden, lots of people received commercial electronic messages marketing and promoting the goods and services of this organisation, this company, this business. And we had lots of complaints because most people, if you're like me, you can't remember what you did 2 days ago, never mind 2 years ago. And they could draw no correlation between the events. And when we went back to the company, they went into their servers and, you know, here's the IP address, this is the data set we have. We wouldn't have this information if they didn't positively opt in. But it's about, it's all about that sort of how you want people to perceive your business and how you drive that communication. Timing is very important. Nothing in the Act talks about timing, but it's very important from your perspective to get that right to drive your business and your products and your goods and services. We do archive the formal warnings and civil infringement notices we've issued on our website at the moment, but reasonableness and natural justice would say we'll come to a point where that will just drop off because it's unreasonable to hold it up there any longer, and we're having some discussions around timeframes around that at the moment. When there's an outcome, so for formal warnings, we will publish relatively quickly. There's information contained within the letters relevant to that happening. We have steps in place relevant to civil infringement notices and the legislative timeframes which we are compelled to adhere to as a regulator, and the person issued with the notice is compelled to adhere to over objections and timings. So we won't publish a civil infringement notice until such time as we've received or considered an objection, altered or amended it, or the person has decided not to pay and we're filing the matter as a notice of claim in a district court. People have tried to push the envelope in relation to informational type messages which wouldn't be considered to be commercial in nature by definition. If you look at the definition of goods and services and link that back to the Consumer Guarantees Act 1971, it's a very, very wide and broad definition, and it encapsulates almost anything. You know, it could encapsulate charitable trusts and philanthropic purposes as well. So it's a wide definition, and it talks about having a link as well in the message as part of a definition of a commercial electronic message. A lot of it is based on our approach on reasonableness, what we see and how we interpret it. Well, you know, we're not here to give people a hard time, but we have to sometimes go by the literal translation of a legislation and its application as we think is appropriate. And it would be really helpful to have some case law around exactly that sort of thing that we're talking about now, and that would be good, but we haven't got that at the moment. But a signature block, maybe not. As I walk the tightrope, I'm not sure. An image in a signature block could be so compelling because it could be very well known. Not a signature, sorry, but an image in a signature block, it could be very much a household and known image, which could portray, arguably, a resonance or a connection with the business and the entity quite well. But yeah, as I say, no case law on that. We don't see an element of maliciousness around that type of activity, and if we did, we would just simply work through it and come to an outcome whereby we were satisfied about what happens. We don't see that a lot, and if a complainant made enough noise about it and we communicated about it, I'm sure we would get to the bottom of it in a sensible way, which wouldn't impinge or penalise the organisation or the business that had sent the message. Absolutely, from best practice. I mean, if you have that response, thank you for opting in to the nominated email address which has been provided, that would be best practice. It's highly, highly, highly unlikely that the inbox has been, or the email address has been compromised as well, that people generally don't go to that sort of trouble, in our experience. No, there's a relationship, you know. It's, yeah, there's a natural friendship there, a natural relationship. Absolutely not.
Well, that was really fascinating discussion. I can see that there's a lot of really good information that people wanted to know from the session. So thank you very much, Tony. We really appreciate your time.
It's okay, it's a pleasure.
And thank you everyone for coming along. So thanks.